As soon as it says I can go, I'll go. Good morning, counselors. We are here this morning to hear arguments on the case of New York State Rifle and Pistol Association et al. V. Kevin P. Bruin. Respondents, would you please introduce yourselves to the court?
I am Daniel Benarek.
And I am Selma Ahmed.
Thank you, counselors. We are going to begin with a series of questions to speak to the primary question of this case, notably the protections of the Second Amendment. To begin, what does the Second Amendment protect?
Your Honor, the Second Amendment protects an individual's right to be able to carry a firearm for the purpose of a militia to fight the government based on the original interpretation. However, a second sphere has been added to the Second Amendment, which is the idea of self-defense within one's home, which is defined in the District of Columbia versus Heller. The Second Amendment no longer only applies to people connected with the militia, but also people who wish to defend themselves in their home. However, it only protects someone's right to defend themselves within their home and not outside of their home.
Thank you, Counselor. Why did the framers include the Second Amendment in the Bill of Rights?
The framers originally included the Second Amendment in the Bill of Rights to protect the rights of the people that they may try to be taken away by the government. Furthermore, if the government does not attempt to act tyrannically as Britain did during colonial time, the people may use their right to a firearm to battle the tyranny of government. In the Federalist Papers, specifically number 29, written by Hamilton in 1788, it stated, in times of insurrection or invasion, it would be natural and proper that the militia of a neighboring state should be marched into another to resist the common enemy or to guard the republic against the violence of faction or sedition. Here, Hamilton clearly states that firearms are necessary for militias to form up as an insurrection and fight off a common enemy of tyranny like Britain was at that time. Furthermore, all original 10 Bill of Rights were made in response to Britain's tyrannical laws that colonists disliked and wanted assurance to have rights to. The Second Amendment was made in response to Britain, which tried to seize their guns, as seen in Lexington and Concord on the 19th of April in 1775. British soldiers attempted to storm into the towns where they had heard colonists had firearms and were planning on disarming them. It's clear in Hamilton that the Bill of Rights was directed towards militias that weren't meant to be unrestricted use of the Second Amendment.
Thank you, Counselor. What are the limits of the Second Amendment's protections?
Yes, Your Honor. Under Cases versus United States and the Federal Firearms Act, the government can restrict or regulate firearms except for prohibiting firearms that correlate to a well-regulated militia. Though through United States versus Miller, the government or Second Amendment does not guarantee a firearm to all individuals or their purposes. The Second Amendment does not hold any guarantee of the Second Amendment towards someone who does not have a reasonable relationship to a well-regulated militia. Lastly, the Second Amendment limits those who may not be in the best state of mind to wield the firearm, such as under age of 21, lack of good moral character, conviction of a felony of serious charges, a fugitive from the law, an addict to controlled substances, being an alien that entered the United States of America illegally or unlawfully, dishonorably discharged from the military, anyone no longer a citizen of America, failure of stating mental illnesses, and involuntarily committing to a felicity of mental hygiene, has had a license of some kind of gun law, license revoked on all sections of the law, can limit or restrict the right of bear arm based off the background check.
Thank you, Counselor. What weapons does the term arms include?
Yes, Your Honor. The term arms is very unclear in the Second Amendment. In colonial arms times, the arms were defined usually as naval power or firearms. As times passed, weapons would continue to change under arms, have been more deadly now. This is why Catiano versus Massachusetts, cleared up and set the precedent for all instruments that constitute bearable arms, even those that are not in existence during the time of the founding. This means weapons were not made during colonial times are in fact included into the term arms in the present day. However, most present day arms fall under firearms. With this, under the Omnibus Crime Control and Safe Streets Act, firearms are any weapon that can be shot out with a projectile, including guns like rifles and handguns, as well as destructive devices. These destructive devices includes bombs, missiles, rockets, and devices with incendiary or poisonous gas warheads. However, these devices of weaponry may be included with arms, but are heavily regulated under the Second Amendment, as they do not serve a purpose towards militia or self-defense, but simply just harm to the public.
Thank you, Counselor. What is the difference, if any, between the verbs keep and bear?
Your Honor, there is a difference in which the verbs keep and bear and keep institutes the legal definition to hold, to maintain, to support, to retain in possession, and take care of. Therefore, keep has to carry a weapon on the person to with the intent to use the firearm, while bear was merely so defined because of how the Second Amendment was written, which constituted to hold the right to have access to a firearm and carry upon the means of self-defense, meaning not on the person at all times. Therefore, keep has a more present and carry definition when compared to bear, which means to have access to something past to present.
Thank you. What is a militia, and why do the framers refer to it in the Second Amendment?
A militia, Your Honor, according to the definition, is all able-bodied civilians eligible by law for military service. Usually, a militia is a military force that engages in rebel activities. That's different than a regular army. It's a military force that is raised from the citizens to supplement a regular army in an emergency. The framers referred to it in the Second Amendment because the colonists used militias to battle British troops to eventually win the war. As referred to its definition of an emergency army, this type of emergency can be seen during the Revolutionary era, where colonists would form militias that were called Minutemen. They held guns to battle British, and because they had firearms ready to use, they were able to defeat the British on standby at Lexington and Concord. In the Articles of Confederation of 1777, it states, "But every state shall always keep up a well-regulated and disciplined militia, sufficiently armed and encountered, and shall provide and constantly have ready for use in public stores a due number of filed pieces and tents, and a proper quantity of arms, ammunition, and equipage." This will prove the importance of the Second Amendment along the lines of militias, as the ammunition and firearms are important to have for protection against for whatever the militia battles, in this context, Britain.
Thank you, Counselor. How should courts determine if a gun control regulation is considered long-standing?
Yes, Your Honor. Courts should determine if a gun control regulation is considered long-standing based upon its merit that has stood up in court of how long it has stayed as a precedent. The New York penal law that's on trial currently has been a law of New York since 1913 and has been through a very similar court case for the same reason of proper cause, as seen in Kachowski versus County of Worcester. It has been a considerable amount of time of the New York law to be longstanding, as its presence of proper cause has been deemed constitutional under the Second Circuit. A gun control regulation can also be considered longstanding by being confirmed by the Supreme Court that the regulation is in fact constitutionally by the Second Amendment, as seen in Heller.
Thank you, Counselor. What is strict scrutiny, intermediate scrutiny, and rational basis review?
Yes, Your Honor. Strict scrutiny, intermediate scrutiny, and rational basis review are all based upon levels of examination of violation of the Constitution. Strict scrutiny is used in the most extreme cases to view laws. The law in question is viewed with intense scrutiny if the law violates a core value of an amendment. It requires that the law must be least restrictive measure in place to ensure that the rights of a large majority are well kept. Intermediate scrutiny is the lower level of scrutiny. It is applied in cases where a law violates a part of amendment that is viewed as a partial core value. This law is viewed under the same scope and allows for a law to be more restrictive in its manner. The exact ruling is that the law doesn't have to make a means to an end, but rather establish a reasonable fit of why it's a law. The final level of scrutiny is rational basis review, is used when no core value is violated. All that has to be proven is to remain constitutional is that the law is related to a government issue.
Thank you. Counselor, is there a difference between openly carrying a firearm and concealed carrying a firearm?
Yes, Your Honor. Openly carrying a firearm in terms of a handgun is usually strapped to a belt on the outside of one's clothing that allows it to be in public's view. A concealed carrying firearm, in this case, a handgun that can be hidden from the public's view to be in a backpack, under clothing, or anywhere non-visible per se.
Thank you, Counselor. And how should the court consider the public safety implications of licenses to carry firearms?
Your Honor, the court should consider the public safety implications of license to carry firearms by considering background checks and the New York penal law. Even if Brandon Kosh and Brandon Nash had good background checks that show that they had no criminal charges, they failed to meet the requirement of a proper cause. For the safety of the public, the true intentions of Koch or Nash are unknown, as anyone with a good background can claim they need a firearm license for self-defense of recent crime, but use it for terrorist-like activity. Because they registered for a concealed gun carry that can be used outside of the home for self-defense, it warrants a distinct regulation for the safety of the highly densely populated state of New York.
Thank you for your answers, counselors. We're going to take a brief recess and reconvene in about 15 minutes for the reading of your briefs.
May it please the court, my name is Daniel B., and this is my co-counselor Selma, and we are arguing for the respondents in the question of whether the state's denial of the petitioner's applications for concealed carry license for the self-defense violated the Second Amendment. My co-counselor Selma will now speak of the facts of the case.
In New York, a person seeking to conceal or carry a firearm must acquire a license from the state. In order to get the license, one must show a special need for self-protection, and the state will determine whether or not to grant the person that license. Robert Nash and Brandon Koch, two law-abiding citizens with no criminal history, applied for the license in the state of New York for self-defense purposes and were denied because they did not demonstrate a special need. The two sued Kevin P. Bruin and Justice Richard McNally with the help of the New York State Rifle and Pistol Association, stating that there is no proper cause to deny them the licenses.
The New York State law, New York Penal Law 400, A-N constitutionally prohibits the license of a concealed gun carry for anyone that does not have a proper cause for the public use under the Second Amendment. With the precedent of Kachowski v. City of Westchester, this law has been tried in the Second Circuit and defined for its importance for the proper cause requirement that would survive constitutional scrutiny, even if it implicated the Second Amendment, as well as New York state courts have defined the term proper cause to include carrying a handgun for targeting practice, hunting, or self-defense. The record must be known that this case is of a self-defense license of the Second Amendment case in public. Therefore, the plaintiff must have a special need for self-protection outside of their home. Self-defense in a home and outside of a home are divergent as presented in District of Columbia versus Heller, which came to the conclusion that the Second Amendment protects the right of a firearms in one's home, not outside. With the appliance of intermediate scrutiny for the safety of the citizens of New York without a proper cause, under no circumstances shall a citizen be given the opportunity for a concealed gun carry outside of a home.
As determined in District of Columbia versus Heller in 2008, it was illegal to carry an unregistered firearm and prohibited the registration of handguns, though the chief of police could issue one-year licenses for handguns. The code also contained provisions that required owners of lawfully registered firearms to keep them unloaded and disassembled or bound by a trigger lock or other similar device, unless the firearms were located in a place of business or being used for legal recreational activities. The ruling was later reversed in the Court of Appeals. One, the Second Amendment protects the right to keep firearms in the home for the purpose of self-defense, and the District of Columbia's requirement that firearms kept in the home be non-functional violated that right. The English Bill of Rights, which was the forefront for creating the Constitution, states, subjects which are Protestants may have arms for their defense suitable to their conditions and as allowed by law. In New York's ratification of the Constitution with proposed amendments in 1788, it is stated that the people have the right to keep and bear arms, that a well-regulated militia, including the body of the people capable of bearing arms, is the proper, natural, and safe defense of a free state, that the militia should not be subject to marital law, except in times of war, rebellion, and insurrection, which stands to what the Second Amendment is defined as in the Constitution, which is that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. A militia in that sense includes the people. The definition of the phrase a well-regulated militia was understood by the Kansas Territory Wyandotte Constitution from 1859. Which stated that the people have the right to bear arms for their defense and security by standing armies in time of peace. are dangerous to liberty and shall not be tolerated, and the military shall be in strict subordination to the civil power. Hence, that it is the right of the people in the military, whose some define as the militia, to bear arms for their defense, meaning that is within the people's right to protect themselves and not just the military. In fact, it is the military who should be dependent on the civil power, hence why the respondents in this case are not seeking guns for a militia, nor does the legislation prevent the creation of such militia. The Second Amendment and its meaning are therefore stretched across the country because of the 14th Amendment's Privileges or Immunities Clause, which protects the fundamental rights of an individual citizen and restrains state efforts to discriminate against out-of-state citizens.
The Second Amendment states that Americans have the right to bear arms, in which bear in this case means to have a weapon and not necessarily carry the weapon on one's person. By having the words keep and bear conjoined by the words arm, it is saying that two central ideas are correlated. By correlating the ideas of a weapon in one's ownership is what is meant by the right to keep and bear arms, and not have been the possession of a gun and carrying it on one person.
The Second Amendment is clarified more in the District of Columbia versus Heller, which made it illegal to carry an unregistered firearm and prohibited the registration of handguns. Although the ruling was in favor of Heller, Judge Breyer in his dissent argued that the court should adopt an interesting balancing, essentially that they can confirm or uphold the restrictions for the benefit of the people in the state. It was shown that in colonial times, specifically from William Blackstone and John Locke, who had a major influence to the founding fathers, that the Constitution and what is in regulated the storage and use of firearms in the home. William Blackstone's commentaries on the law of England on the right to keep and bear arms serve to protect and maintain to inviolate the three great and primary rights of personal security, personal liberty, and private property, which makes no distinction on whether the government can control the rights or not. John Locke, the true father of our Declaration of Independence, stated that they are ready to tell you that it deserves death only to ask after safety. Betwixt subject and subject, they will grant there must be measures, laws, and judges for their mutual peace and security. But as for the ruler, he ought to be absolute and is above all such circumstances. Because he has more power to do hurt and wrong, it is right when he does it, to ask how you may be guarded against harm or injury on that side where the strongest hand is to do it. Is presently the voice of faction and rebellion, as if when men quitting the state of nature entered into society. They agreed that all of them but one should be under the restraint of laws, but that he should still retain all the liberty of the state of nature, increased with power and made licentious by impunity. John Locke in his previous statement states that the government and subjects need laws and judges for their mutual peace and security, and essentially that the government, when needed, will need to step in order for the people's safety. James Madison, the founder who proposed the Second Amendment, wanted to prevent standing militia due to what they thought about the military at the time. Therefore, by allowing the people to bear a weapon, they will be able to protect themselves in case of any danger. However, because it states being necessary to the security of a free state, it is meant to protect the United States in times of need.
Under the New York Penal Law 400 requires an individual to show proper cause to evoke the right to carry a concealed gun, regardless of their character. This law and precedent of proper cause has been apparent in New York since 1913. The purpose of this law is to figure out one's true intent behind owning a gun instead of just claiming it's for self-defense, as anyone else could do that would meet the rest of the requirements like showing good character. The record must show that the proper cause includes target practice, hunting, or self-defense means of a license, but the license that was restricted under the New York law was a full carry license, which would permit the user to freely use their concealed firearm in the highly densely populated state of New York. This idea can be seen in Matter Moore versus Gallup, in which good character and proper gun training is not enough for someone to get a good license. Therefore, Caution Nash's reasons for getting a gun license of evident training and good character are not enough to get a gun license. As presented in Kachowski versus County of Westchester, proper cause is meant to be a special need for self-protection. This special need is directed towards people who have a clear reason that is different from just crime. The application must demonstrate a special need for self-protection distinguishable from that of one general community or of persons engaged in that same profession. The precedent is seen in Kelowski versus New York City Police Department. This precedent is what licensed officers deem someone's application to have a proper cause. In Bernstein versus Police Department of the City of New York, they stated a generalized desire to carry a concealed weapon to protect one's person and property does not constitute proper cause. The purpose of self-defense in and out of home is not enough to allow someone to have a full carry license. While District of Columbia v. Heller deemed that the Second Amendment right covers the right to defend oneself in their home, it does not cover both inside and outside the house, nor does it cover concealed weapon gun carry. While this case of the NRA v. Bruin questions a full carry license that would allow someone for a concealed gun inside and outside of their home. Additionally, Kachowski v. City County of Westchester and New York State Rifle and Pistol Association, Inc. versus Bruin both include plaintiffs that are restricted by the same New York penal law for the same reason: failure to demonstrate proper cause to obtain a full carry license. It has already been deemed by the Second Circuit that the proper cause is necessary under intermediate scrutiny. Proper cause must be enunciable rather than conjectural. One may argue that the New York penal law restricts another Second Amendment right to bear arms, though the right to regulate who controls weapons has been evident since the Gun Control Act of 1968, which basically bans most felons of their Second Amendment right of a firearm. The New York Penal Law 400 restricts people the use of a gun for A, under age of 21, B, lack of good moral character, C, conviction of a felony of serious charges, D, a fugitive from the law, E, an addict from controlled substances, F, being an alien that entered the United States of America illegally or unlawfully, G, dishonorably discharged from the military, H, no longer a citizen of America, I, failure of stating a mental illness, J, been involved and committed to a facility of mental hygiene, K, has a license of some kind, like a gun license, revoked, are all sections of the law that can limit or restrict the right of bear arms based off a background check. The Brady Handgun Violence Prevention Act, also known as the Brady Act, in 1994, which imposed the federal background checks on individuals to own weapons or license for weapons and would lead to more universal background checks in the federal and state government. It was recorded by the FBI that gun violence had significantly gone down because of the Brady Act. From 1993 to 2006, gun-related homicides reduced by 32% as well. It was also reported that the Brady law stopped 2 million firearm sales to ineligible individuals, seen in gun control topic overview. It was replaced by the modernized National Instant Check System, which basically did the same, just modernized. The purpose of these background checks is to make sure that whoever applies for a license or purchasing of a gun will be checked and held liable for their past misfortunes. The purpose of proper cause is to restrict someone from obtaining a gun license so easily, just like the background check does so as well, both of which regulate the people's Second Amendment to inhabit protection among other citizens and make sure only rightful owners are owning firearms. Proper cause has more recent study of what the person needs the gun for. People can change for the worse where the background will mean nothing, like the El Paso, Texas shooting on August 3rd, 2019 that resulted in 23 dead. Patrick Colsius, who legally purchased a gun, passed the background check, but his reason to own a gun was for clear violence towards Mexicans, but this was not reported for why he got the gun. People who can show good moral character can obtain a gun easier and therefore use it to commit violence effortlessly. Therefore, the purpose of proper cause is to study the person's means and business on a regular basis that makes them different from the average person that will cause them to be targeted by violence. This can include jobs like merchants, storekeepers, bankers, and people who move large amounts of money with the means to defend oneself from people who may target them to rob, just as shown as matter of Kowalski versus New York City Police Department, which defines that people need to have high amounts of money transferred to demonstrate a true proper cause.
One can argue that because of the Privileges or Immunities Clause in the 14th Amendment, that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, meaning from their rights from the government. However, in the United States versus Cruikshank, the Supreme Court rejected this interpretation. The term militia is also interpreted to be among the people. However, it was initially meant for the military, but as the Constitution was written, it was later written towards the people. Without saying by using the word militia, one is not limiting.
The petitioner may claim that this case must be looked at under strict scrutiny of the Second Amendment. One may argue that strict scrutiny must be applied due to past precedents of having applied strict scrutiny on the Second Amendment, such as District of Columbia v. Heller. In District of Columbia v. Heller, the DC law consisted almost as a ban on handguns rather than restrictions, which denied citizens of their Second Amendment. The handgun had to be unloaded, disassembled, and locked up in a safe if one was even to acquire the license for a gun, which was difficult as it was already. Individuals were denied to own a firearm inside their home for self-defense purposes. While one could argue that strict scrutiny was used, it was debated in the court whether they use a specific level of scrutiny upon the determination of the court. The respondent asked the court to examine it with a strict scrutiny test, as they believed the law benefited the government rather than the people. This precedent was seen in Abrams v. Johnson, which concluded that districting plan must be narrowly tailored to serve a compelling government interest in order to survive. Continuing in the court of Heller, the court denied the use of strict scrutiny because it was under the Second Amendment, which restrictions are meant to entail under the Second Amendment for public safety. The court did not cite a specific level of scrutiny in making its decision. However, Justice Breyer wanted to examine the case without any form of scrutiny, instead based upon something called an interest balancing inquiry that would go off a rational basis standard that would rationalize the purpose of the law to save people's lives versus the constitutional right itself. Strict scrutiny would jeopardize the end court ruling by avoiding what the benefactor of the law is in the first place. Therefore, the standard of the strict scrutiny should be avoided if possible to hold a true decision of the court in terms of the Second Amendment, as it is meant for the protection of the people, but also destruction of the people when regulated or restricted in particular cases. In the current case, New York State Rifle and Pistol Association, Inc. versus Bruin, the New York penal law has the purpose of restrictions for the protection of the people from gun violence. It should be examined under strict scrutiny, but instead not be examined by under strict scrutiny, but instead intermediate scrutiny. This idea can be seen in the Second Amendment case with the same New York law of proper cause, Kachowski versus County of Worcester, where some form of heightened scrutiny would be appropriate. Scrutiny was not necessary, and instead applying intermediate scrutiny, as well as holding intermediate scrutiny is appropriate where a firearm regulation does not burden the core protection of self-defense in the home. As depicted in Kachowski, New York State Rifle and Pistol Association, Inc. v. Bruin should not be held under strict scrutiny because as it does not take away a core value of the Second Amendment of stopping an individual from self-defense that was defined in District of Columbia v. Heller, but instead finds the means to regulate the Second Amendment for firearms to be in the hands of rightful owners for the protection of the citizens of New York.
The historical understanding of the Second Amendment has been defined under common law to be the right to have a weapon and not necessarily carry the weapon on one's person, which is clarified more in the District of Columbia versus Heller. Although that case ruled in favor of Heller, it was stated in a dissent that the court should be able to have restrictions for the benefit of the people in the state under New York Penal Law 400, contained provisions that the Second Amendment gives you the right to have a weapon, but not necessarily carry it out of the home, which is referenced as well in that case. The right of the person to bear arms is not infringed upon by the law in New York. It is simply stating that people need to have a proper cause to carry that weapon outside of the home. Proper cause has been defined under the penal law to be a special need for defense other than just self-defense. This is because the license is a non-restricted license that admits the right to be used a concealed gun in public. This is the purpose behind the proper cause, which is to make sure that the user is kept in check within their background check of their purpose to wield a weapon other than high crime rate. To add on, intermediate scrutiny should be applied as the entire Second Amendment is not being violated, but instead regulated for the protection of the people of New York as it has good reason to be there. Thank you.
Thank you.